everyone, welcome to School Slow again, and it's me Salamot. And today we are going to be talking about consideration under contract law. So in our previous videos we've discussed the elements needed to form a valid contract. We've said that you need an offer, there has to be acceptance of that offer, and then there has to be payment of consideration, among other things. So today's video is going to be centered on consideration and what it is. So stay tuned. If you have not subscribed, please subscribe. If you have subscribed, turn on the notifications button so that you can be notified when we post new content. Now, consideration under contract law, like I said, is one of the things that needs to be present to form a valid contract. It is the price you pay in exchange for the contract, basically. Okay. So remember that we said that an offer is a promise, right? And then acceptance is when you accept the promise. Now you must, in addition to that, give what we call consideration for the promise. Is the price you pay, is what you give, like I said, in exchange for the promise that has been made. Okay. In Curie versus Misa, it was held that consideration is a right, benefit, or interest that accrues one party, or some forbearance, detriment, or loss that is suffered by the other party. So without consideration, regardless of whatever form it takes, as has been said in Curie versus Misa, there can be no contract. Okay. At common law, a contract not under deed is only sustained by the presence of consideration. Basically, that a contract that has not been reduced into writing is unenforceable unless and until some consideration has been given for it. Consideration may take various forms. Okay, it could be an act, it could be forbearance to act, basically meaning that you have the right to do something, but then you forbear, you decided not to do it. Okay, owing to a promise that has been made. So that forbearance itself can amount to consideration for the promise. And then it could also be an exchange of promises. An example is in a case called Efrifa versus Class Peters, where the two people, the claimants and the defendants, had agreed or had promised to marry each other. Okay, that exchange of promises was held to be consideration enough to, ground the contract and make it enforceable, so that when one party pulled out and decided he wasn't going to marry again, the courts enforced it against him. Right. One thing you need to note about consideration is that it only has to be sufficient and not adequate. Now, in everyday English, these two words seem like they are similar in meaning, but then in law, they mean separate things, or they mean totally different things. When we say consideration is adequate, we mean that it matches the value of what it is being given in exchange for. Okay, if I promise to build you a house, a 3-bedroom house, and you are going to give me consideration in terms of money, you should be able to give me consideration that reflects the 3-bedroom house I'm going to build. You cannot pay me 500 cedis for building you a 3-bedroom house. Okay, someone will say, or most people will say, it doesn't match. Okay, that is adequacy. Okay, now sufficiency has to do with something that the law is satisfied with. Okay, so if, with the example I just used, I'm paying you, or you are paying me 500 cedis for building a 3-bedroom house for you, and I knew that you were going to pay 500 cedis, and I was satisfied with it, and you didn't force me. There was no element of fraud, there was no element of duress. I accepted the 500 cedis. Okay. Then, in that case, I cannot later come and say that it wasn't enough. The law would recognize it as sufficient. Okay. A case that shows this example I'm attempting to give is a case called Ejabeng versus Kwabla. In this case, the parties had agreed for the sale of a house. In fact, not the parties, but then the defendant and then the father of the claimant had agreed for the sale of a house for a certain amount. Now, the father dies, and this child says that to him, it doesn't make sense that that house was sold to the defendant at the amount that it was sold, because he thought the house was more valuable than the amount it was exchanged for. Now, the courts said that just because consideration given was not adequate or it was too small does not mean that the entire contract is void in the absence of fraud or in the absence of misrepresentation. Okay, so unless you can show that there has been misrepresentation or there has been fraud, the lack of adequacy of consideration, in other words, the inadequacy of consideration, is not a reason why the court will hold that the contract is void. Okay, once it is sufficient in the eye of the law, and for it to be sufficient in the eye of the law, there just must not have been duress, misrepresentation, or anything like that. So if you decide to part with your house for 100 cedis, that is your business. Okay, it doesn't mean that the consideration was not enough. Now, there are 3 types of consideration. Okay, you have executory consideration, executed consideration, and past consideration. Consideration is executory when it is outstanding on both sides. Okay, what that means is that the parties have both made promises and they are yet to actually carry out their promises. So you see in Efrifa versus Class Peters, they had both exchanged promises to marry each other. They were yet to get married. Okay, but the court thought that it was enough consideration. It was because under that circumstance, the consideration was executory. It looks to the future. It is yet to be done. Consideration is executed if one party has executed their part of the consideration, has given their consideration, awaiting the other party to also do theirs. So executed consideration would arise in unilateral contract or unilateral agreement. You can check our previous videos on those, what that means. But then basically it means that there has been an act in exchange for a promise. Okay, so in that case, you would see that the party who is supposed to do an act or who is supposed to give an act has already done theirs, awaiting the person who has made a promise to execute his. And a case that shows this is Carlisle versus Carbolic Smoke Ball. You can read it in your, free time. We'll talk about it another time. Then you have past consideration. Now, consideration is past if it is given before the promise was made. Now, this is a bit confusing, but get this. You give consideration in exchange for an agreement or in exchange for the promise. Okay. Now, it is possible for you to have done something for someone, and then later on, the person says that having looked at what you've done for me, I promise to do this and that. Right? Now, the person is making the promise in light of your act, in light of what would be the consideration. In future, if you want to hold the person to their promise, what would you cite as your consideration? You would cite what you did for them as your consideration. But the law has said that this type of consideration is past and unenforceable. Okay. So the rule is that past consideration is not good consideration. Okay, so if the consideration you are relying on to enforce a promise is past, the court would not enforce it because the consideration in this case is past and it's not good. A helpful case to understanding this concept of past consideration is not good consideration, however, is a case called Eastwood versus Kenyon. Now, in this case, a man died and left his daughter to the claimant. And according to the claimant, he borrowed money to take care of her. She grew up, became a responsible young lady, and got married to the defendant. Now, when she grew up, she promised to pay back the claimant for all that he has spent on her. Right? Now, when she got married to the defendant also promised to pay him for all that he has done taking care of his wife. Now, they both defaulted, and so he brought an action to court to recover his amount. The court said that the consideration is past because the actions he did, taking care of the young lady, came before the promise to pay. Right? She only promised to pay after she had grown up and become an adult. What you give as consideration for her promise came before the promise. And remember, like I said, it is supposed to be given in exchange for the promise. Okay, so it cannot come before the promise, right? So, like I said, in your free time, you can read the case of Ray Mercado, which also talks about this principle. However, there are some exceptions, okay, to the principle that past consideration is not good consideration. One of them is that if the act was specifically requested for by the defendant, then it will be binding on him. Okay, the promise will be binding and the consideration will be good in this case. And a case that shows this is a case called Lampley versus Braithwaite. Now, in this case, defendant killed a man and he asked the claimant to write to the king and petition him for pardon. Now, the claimant was successful, and so the defendant promised him £100 after he had successfully petitioned the king. He defaulted, and so the claimant brought an action to recover the £100 because, he promised him so. The defendant said that the consideration was passed because he did the act before the defendant promised to give him the £100. But the court thought that in this case, the act, which is that he should go to the king and petition him for pardon, was one specifically requested for by you, the defendant. And so in this case, even though the consideration is passed, the rule that past consideration is not good consideration would not hold. Okay, because you specifically asked him to do something. He did that and then you promised to pay him. So you must pay. Another instance where past consideration is not good consideration, that rule does not apply, is an act done by way of business. The presumption is that when you do something in the course of business, it is meant to be paid for. Okay, so even though before the act was done, the parties may not have talked about the giving of consideration, or that the issue of consideration came up after the action had been done, it will not be considered past consideration because it was done. Whatever action the person did, he was doing it because you were going to pay him. For example, you call someone to come and do your laundry for you, and the person does the laundry. That's the business the person trades in. And you call the person, she comes to do your laundry, and after that, you say you are going to pay her 100 cedis. She goes around to other houses to do her work, and then when she comes back, you say that the promise to give her the 100 cedis came after she had done whatever she did for you, and so it is not binding. In this case, it won't be binding. That's her job. That's what she does. Okay, so because she did the laundry in the course of her business, or you did whatever it is that you guys did in the course of business, then in that case, even though the consideration she gave, i.e. the laundry, is passed, it will still be binding. This is where we end today's video. We talked about consideration under contract law, the definition, some cases. We talked about adequacy of consideration as against sufficiency of consideration. And we've talked about the types of consideration and the cases that support what these types are. This is where we end the video. I'll see you again in another video where we talk about promissory estoppel and some changes that the Contracts Act 1960 has made to the doctrine of consideration under common law. Until then, bye.